Good evening everyone. Welcome to another video with Pratham Test Prep. This is your host Sushila Chaudhary and today we'll be talking about the new criminal laws that are set to reshape the legal version in India. Now, in a significant development set to reshape India's legal landscape, the Union Home Ministry has announced the impending enforcement of three new criminal laws. Scheduled to be effective from July 1 this year, these laws, Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam, will replace the long-standing pillars of the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act. The Union Home Ministry's issuance of a Gazette notification signaling the implementation of these laws marks the culmination of an initiative aimed at modernizing and streamlining India's criminal justice system. The genesis of these transformative legislations dates back to December 2023, receiving the President's assent and marking a significant milestone. These bills were introduced in Lok Sabha on August 11, 2023, the bills underwent a scrutiny by a parliamentary committee chaired by Dr. Brijlal before gaining approval in the Lok Sabha on December 20. Subsequently, they secured a passage in Rajya Sabha on December 21, culminating their adoption. Now, let's talk about all these laws individually. So, first, the way we're going to be discussing is first we are going to discuss the laws that are already currently present, currently applicable, and then their new version that is going to be applicable from July 1st. Now, Indian Penal Code of 1860 is a cornerstone in India's legal framework, and it continues to play a pivotal role in defining and categorizing criminal offences. Enacted during the British colonial era, the IPC covers a spectrum of crimes prescribing punishment and upholding principles of justice, addressing offences against person, property, public order, morality, decency, religion, and the state. It remains relevant through amendments and modifications despite its historical origins. The IPC remains a crucial legal document guiding India's criminal justice system, ensuring the investigation, trial, and punishment of offenders while adapting the contemporary societal view. Now, the act replacing Indian Penal Code is Bharatiya Nyaya Sanhita. Now, this was introduced in Lok Sabha on August 11, 2023, and aims to reform the criminal justice system in India by replacing the Indian Penal Code of 1860. Now, notable changes include removal of sedition, introducing new offences related to secession and terrorism, and addressing organized crime. The bill prescribes severe penalties for terrorism, including death penalty or life imprisonment, and introduces penalties for organized crime and petty organized crime. It also establishes separate penalties for murders based on caste, race, and extends the death penalty for gang rapes of minor and penalizes intercourse by deceitful means. The bill expands the scope of certain offences to include boys and overall presents a more modern and comprehensive legal framework. Now, when this bill was submitted to the Standing Committee on Home Affairs, which was led by Mr. Brijlal, they submitted their recommendations on the Bharatiya Nyaya Sanhita bill, which and the committee suggested retaining adultery and incorporating section 377 for non-consensual sexual offences, and reverting to unsound mind instead of mental illness. The committee proposed separating organized crime offences and attempts, clarifying general feelings of insecurity and defining intimidation in terrorism, and seeking clarity on community service as a punishment for causing death by negligence. It recommended limiting the provisions to motor vehicle accidents. Now, let's talk about the next act, which is important in our criminal legal landscape. It is the Code of Criminal Procedure. Now, the Code of Criminal Procedure of 1973 is a comprehensive framework for the procedures to be followed in criminal cases, from filing the first information report to the final disposal of the case. Now, it was enacted to consolidate and amend criminal procedure laws, and it applies nationwide and covers arrest, bail, investigation, trial, appeal, evidence, judgment, and sentencing. The CRPC ensures fair trials, protection of rights, and outlines procedures for magistrates, warrants, and summons. It also addresses juvenile justice and the maintenance of public order, playing a crucial role in Indian criminal justice system. Now, talking about the Bharatiya Nagrik Suraksha Sanhita 2023, presented in Lok Sabha on August 11, 2023, aims to replace the current Code of Criminal Procedure 1973. While preserving key elements, the bill introduces noteworthy changes, including allowing electronic trials and expanding the range of offences requiring forensic investigation. It modifies provisions related to under trial detention, enabling release on bail for first time offenders after serving one-third of the maximum sentence. The bill empowers any police officer to request a medical examination of the accused and grants Metropolitan Judicial Magistrate broader authority to order specimen signature, finger impression, and voice samples. Specific timeline for procedures are introduced, and trials can proceed in the absence of proclaimed offenders for serious offences. The bill eliminates the provision designating metropolitan areas and magistrates based on population size. Overall, the legislation aims to modernize and streamline the criminal procedure in India. Now, the standing committee recommended alterations to empower subordinate officers for investigation grave offences under BNSS, so that is Bharatiya Nagrik Suraksha Sanhita, and it recommends modifying under trial release conditions, addressing concerns about 15-day detention periods, and incorporating audiovisual recording safeguards. Changes to life sentence commutation prompted a call for specifying minimum and maximum sentences. Now, lastly, the act that is going to be replaced is Indian Evidence Act of 1872. Now, the Indian Evidence Act of 1872 was enacted during British colonial rule, and it establishes rules of admissibility, relevancy, and weight of evidence in Indian courts. It is applicable to both civil as well as criminal proceedings, and it defines relevant evidence, sets criteria for admissibility, and addresses various types of evidence. The Act regulates witnesses, including competency and testimony, incorporates the hearsay rule, recognizes privileged communication, and governs the opinion and expert evidence. And it also classifies public documents, allocates the burden of proof, includes the doctrine of estoppel, and outlines principles of determining relevancy and irrelevancy. Despite amendments and interpretations, the Act remains a foundational document in the Indian legal system, ensuring fairness in legal proceedings. Now, the bill replacing the Indian Evidence Act is called Bharatiya Sakshi Bill. It was introduced in Lok Sabha on August 11. Now, while preserving certain elements of the original Act, it makes significant changes, including the inclusion of electronic records as evidence, extending the concept of oral evidence to electronic information, broadening the category of secondary evidence, reaffirming document production provisions with exceptions for privileged communication, and addressing joint trials. The bill modernizes evidence admissibility standards, accommodating the electronic age while retaining core principles of the existing Act. Now, the Standing Committee on Home Affairs presented findings on the Bharatiya Sakshi Bill, aiming to replace the Indian Evidence Act. So, according to the Standing Committee, the BSB, that is Bharatiya Sakshi Bill, retains provisions of Indian Evidence Act, but designates electronic records as primary evidence. The committee recommends safeguards for electronic evidence, aligning Bharatiya Sakshi Bill with Clause 63 of certificate authentication and amending deficiency in electronic certificates. It questions the insertion of facts in issue in the Bharatiya Sakshi Bill and recommends its deletion also. So today what we have seen, that we have talked about the three bills that were introduced in our Lok Sabha on August 11, and after being introduced and getting assent from the President, these bills are set to come into force very soon, and that is by July 1st they will come into force. Now, as India prepares for this transformative transition, the forthcoming implementation of Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshi Adhiniyam signals a paradigm shift in the nation's criminal justice system, a testament to the pursuit of more equitable and just society. Thank you so much. That was all from our side today. Thank you so much for watching. If you liked the video, please like, comment, and share with like-minded people, and subscribe for more such exciting and keep yourself updated on legal news. Thank you so much.